There's a room in a county courthouse where a judge who never met you, never met your kids, never sat at your kitchen table decides who raises them. It happens more than you'd think, not because anyone did anything wrong, just because nobody left a piece of paper. Right now, only about 1 in 4 American adults has a will, and the single biggest group with no plan at all, no will, nothing, isn't who you'd guess. It's parents, people with kids under 18, the exact people with the most to lose. Most of them believe the same thing. They believe that if something happens to them, the people they love will just step in, that it's obvious, that everyone already knows who'd take the kids. The law doesn't work on what's obvious. If both parents are gone and there's no name written down, the state doesn't guess. It opens a case, and relatives who all swore they got along can end up on opposite sides of a courtroom, each one sure they know what you would have wanted. There's a way to keep that decision yours, one page. The catch is what most people get wrong about it. What most people get wrong is simple. They think this is about money. They picture the will as the thing that splits up the house and the savings and grandpa's watch. And it is, that part's real. But for a parent with young kids, the money is the smaller problem. There's a second thing happening at the exact same time on a totally separate track, and almost nobody plans for it. Who actually gets to raise the children? Those are two different questions, decided two different ways. Who gets your stuff if you leave no will? Your state has a built-in list for that. Spouse first, then kids, then parents, then siblings on down the line. You don't get a vote, but at least the list exists. Who raises your kids is not on that list. That one gets decided by a judge, in a courtroom, in a case somebody has to open. So let's slow down on the scary part for a second, because the title makes it sound bigger than it always is. Here's the piece other channels skip. If you've got two parents and one of you dies, the other parent almost always just keeps the kids. That's the default. No one swoops in. You'd have to do something pretty extreme for a fit, living parent to lose their own children. Where it gets dangerous is narrower, and it's a situation way more families are quietly in than they admit. A single parent, no other parent in the picture, or both parents in the same car. When there's no surviving mom or dad left to step in, that page you never wrote becomes the most important document in your kid's life. And in that moment, the court doesn't know your sister is the obvious choice. It doesn't know your best friend has practically been a third parent since the twins were born. It doesn't know your own mother, the one everybody assumes would take them, is 68 and terrified and quietly praying somebody else volunteers. A judge knows what's written down, and if nothing's written down, the judge has to figure out what's best for a child they're meeting for the first time across a courtroom. I want to be careful here, because this is somebody's actual kids we're talking about, and a video can't know your family. But the pattern is real, and I've watched the version of it more than once. Two relatives, both good people, both certain you know what you would have wanted, and now a courtroom is the only place left to settle it. And the kids are old enough to feel every bit of it. Here's the part that should make you a little angry. What fixes this is almost insultingly small. In most states, you can name the person who'd raise your kids in a will, or, and this is the part people don't know, on a separate signed page all by itself. One sheet, not a contract, not 40 pages of anything. A piece of paper you could fill out at your own kitchen table tonight with a regular pen. You write down who, you sign it the way your state requires. That's the one page in the title. It's a guardian nomination. Fancy phrase, plain job. It's you telling a future judge in your own words who you trust with your children. And now I have to disagree with basically the entire estate planning industry for a second. Every ad aimed at parents wants to sell you the big package, the trust, the bundle, the $400 starter plan, the whole thing. Fine, some families need all that, but the single most powerful thing a parent of little kids can do is also the cheapest, plainest part of the whole pile. That page that says who. People will spend months agonizing over how to split up assets they don't even have yet and skip the one piece that decides who tucks their kids in at night. Now, does that page stop the state, like the title says? Not exactly, and I'd rather you hear the real version from me than find out the hard way. That page doesn't lock the court out. A judge still has to sign off. In every state, that judge keeps the power to say no if the person you picked is truly unfit. And good, you'd want that. What that page actually does is flip the whole thing in your favor. Instead of a courtroom starting from zero, it starts from your choice. And in most places, your choice wins unless there's a real reason it shouldn't. How much does it cost to make it official later after you're gone? Depends where you are, but it isn't free. In California, just to file the paperwork asking a court to confirm a guardian, there's a fee, $225 for the person who'd raised the child, $435 if money's tied up in it too. Add weeks of waiting, add forms with names like GC210 that nobody outside a courthouse has ever heard of. I'd love to give you a clean statistic right here, how often this actually blows up into a real fight between relatives when there's no page. I went looking, and I couldn't find a number I trust enough to say out loud. Anybody who hands you a tidy percentage on that is probably guessing, and I'm not going to guess at you about your kids. But you don't need a statistic to feel where this goes. You just have to picture the gap, the space between the day something happens and the day a judge finally decides. Weeks, sometimes months, and somebody has to be holding those kids the entire time. That gap is where the real cost lives. Not the filing fee, not the forms. What happens to a child and to the people who love that child in the months nobody planned for? It looks like this. Picture two families, same street almost, same kind of life, same unthinkable Tuesday where everything stops. In the first house, a parent, months or years earlier, on some ordinary night, sat down and filled out that page, named the person, signed it the right way for their state, stuck it in a folder with the birth certificates. In the second house, the parent meant to, knew they should, never did. Now watch what the law does with each one, because this is where the title earns it or doesn't. In both houses, the same thing has to happen first. Somebody who loves these kids has to step forward and ask a court for permission to be the guardian. There's no skipping that. Even the named person, the one you picked, has to go file. They walk into a courthouse, fill out a petition, that GC 210 type form, and ask a judge to make it official. While that's pending, if it's an emergency, a court can name a temporary guardian fast, just to have an adult legally in charge while the real decision gets made. Here's where the two houses split. In the first house, the judge opens the file and finds your page, your words in your words. And in most states, that flips the courtroom from a blank slate into something closer to a rubber stamp. Not automatic, but heavily tilted towards the person you picked. A judge who'd otherwise be guessing is now just checking one thing. Is this person fit? Yes, then it's basically done. Fast, quiet, about as gentle as a courtroom gets for a kid who just lost everything. I had to read one state's rule twice because it honestly didn't sound legal to me. In Georgia, if both parents name the same guardian in writing and that person agrees and nobody files an objection, the court is required to hand over guardianship. No best interest hearing, none. A judge doesn't get to second guess you. And if somebody does object, they've got 10 days to file it. The court holds a fast hearing inside 30 days. And watch this. To beat your choice, that person has to prove, with clear and convincing evidence, which is a high bar, that the person you picked is actually unfit. Not, I'd do it differently, unfit. Your written word in that state is close to law. Why does a piece of paper get that kind of power? Because of something the Supreme Court said back in 2000 in a case called Troxel. Strip out the legal language, and it comes down to this. A parent's right to decide how their own child is raised is about the oldest, most protected right this country recognizes. Courts start from the assumption that a fit parent was acting in their kid's best interest. So when you write down who should raise them, a court treats that as your judgment talking, and your judgment on your own child gets enormous deference. Now, the second house, no page. A judge opens the file and finds nothing from you. And the strange thing happens. Your silence becomes an invitation. Anyone with a connection to those kids can petition. Your sister files. So does your late spouse's brother, the one you never trusted, who shows up in a press suit and means every word of it. Now there are two petitions, two sets of relatives, and the judge starting from scratch. Interviewing, evaluating, sometimes appointing a separate person just to investigate what's best for the child. Weeks become months, and the kids are living somewhere in the middle of it, in a house that may or may not be the one they'll stay in. Same school one month, maybe not the next. New adults making calls about bedtime and doctors and which parent's photo stays on the wall. None of them quite sure they have the right to. Trauma on top of trauma. They already lost a parent, now they're not sure where they live. And quick tangent, because a real mind wanders here, there's a whole second mess running alongside this if those kids inherit any money. A court usually locks a child's inheritance in an account nobody can touch until they're 18, with its own separate guardian over just the money. Different job, different headache, whole other video. Back to the page. I have to be straight with you about its limits, because the internet oversells this. That page is not a magic word. Two things can sink it. First, and this is the one nobody likes hearing, a living fit parent usually beats your choice. If you're divorced and you name your sister because you can't stand your ex, but your ex is still a legally fit parent, in most states, that ex has the stronger claim to your own kids. That page doesn't erase the other parent. Second, and this one's just sad because it's so avoidable, a page that isn't done right for your state can be worthless. Some states want 2 witnesses, some want it notarized, some want it actually filed with the court before it counts. California's pretty relaxed, signed and dated does it. Florida wants the thing filed with the clerk. Get the formalities wrong, and the most heartfelt page in the world is just the kind note a judge isn't bound by. So the page is powerful. It is not bulletproof. What's different between those two houses isn't luck and it isn't love. Both parents love their kids exactly the same. What separated them was 20 minutes and a signature one of them got around to, which raises the only question that actually matters now. If you're in that second house tonight, no page, kids asleep down the hall, what do people actually do about it? Not someday, this week. So here's what people in that second house actually do, and the order most of them land on without anyone telling them. It starts with the part everyone thinks is the legal part, but isn't. The hardest move isn't a form, it's a name. Sitting down and actually deciding who. And this is where most people stall out for months, sometimes years. Not because they don't care, because they care too much. They run the list. The sister who'd love them but lives in chaos. The brother who's stable but 3 states away. The best friend who'd be perfect except they've never once said the word out loud to each other. Nobody fits clean. So they wait for a name that feels obvious and it never comes. And the page stays blank. I'll say the thing I'd say to my own family here. You are not looking for someone who will raise your kids exactly the way you would. That person does not exist. Not your sister, not your mother, nobody. You're looking for who comes closest and who you'd trust in the room if you couldn't be in it. A good enough name written down tonight beats the perfect name that lives only in your head. The blank page is the only truly wrong answer. And whoever you land on, ask them out loud before you write it anywhere. This sounds obvious and people skip it constantly. And then a guardian is named who, at the worst possible moment, quietly says no. It's an awkward conversation. If something happened to me, would you raise my kids? There's no smooth way to start it. But the people who have that conversation are spared the version where a court finds out the named person never agreed in the first place. Then it goes on paper, the way your state actually wants. 2 roads here. One, you fold it into a will, which a lot of people do anyway, and a simple will isn't the monster they fear. 2, in most states, you can do that standalone page all by itself, a guardian nomination signed the way your state requires. And that the way your state requires part is the whole ballgame, because we already saw a perfect page mean nothing when the formalities are off. Some states want 2 witnesses watching you sign. A few want a notary. A couple want it actually filed with the court before it fully counts. What do people do who can't afford a lawyer for this? More than you'd think. Nearly every state court has a self-help center. Real people who will walk you through the guardianship forms for free, the GC 210s of the world. There's lawhelp.org, which points you to free legal aid in your own state. There's ABA Free Legal Answers, where if money's tight, a real volunteer attorney in your state will answer your actual question in writing. None of that is a secret. It's just buried under 1,000 ads from companies who'd rather sell you a package. Now, the move people botch even after they've done everything right is they hide it. The page goes into a safe deposit box only they can open, or a fireproof safe nobody else knows the code to, or a folder so organized that in the chaos of an actual emergency, no one thinks to look. A document nobody can find at the moment it's needed is functionally a document that doesn't exist. So what folks tend to do is tell the person they named, "You're it, and here's where the paper lives," and keep a copy right there with the birth certificates and the social security cards. A few states let you file it with the court for safekeeping, which takes the guesswork out entirely. One more, and it's the quiet one. Life moves. You get divorced, a new baby shows up, maybe the person you named moves to another country, or you two stop speaking, or, and this happens, they pass before you do. A page from 6 years ago can name someone who isn't even an option anymore. People who get this right don't treat it as one and done. They glance at it when the big stuff changes, and that's usually enough. If there's two parents in the picture, both of you doing this together matters more than people realize. Some states flat out require both parents to agree on the nominee. A page where the two of you point at different people isn't strength. It's a fight you've preloaded for a courtroom. And here's where I get careful, the way you'd want me to. If your situation has sharp edges, a child with special needs, real money on the table, an ex you're worried about, a blended family with stepkids who aren't legally yours, that's the point where you stop taking direction from a video, even a careful one, and you sit down with a lawyer in your own state for an hour. Not because the page doesn't matter, because your situation has enough moving parts that getting it slightly wrong costs more than the lawyer does. A good one, for something this contained, is often cheaper and faster than the fear in your head says it'll be. But for a whole lot of people, none of that applies. It's just a parent, a couple of kids, and a page nobody ever got around to. So picture the folder, the one with the birth certificates, the shot records, the little hospital bracelet somebody saved. There's a slot in there, whether you've noticed it or not, where one more page is supposed to go. The page with a name on it. Right now, for most people watching this, that slot is empty. It takes a pen and 20 minutes and one uncomfortable phone call. That's the whole price. I don't know why nobody hands you that page at the hospital the day you carry them out to the car for the first time. Feels like they should. They give you everything else.